So you'll notice for those who are watching, both me and Will are not in our usual environment.
Oh,
So
got it.
we're juggling screens and doing all sorts of stuff. Right, I think yeah, that's cool. Right, let's So it's nearly 7:30. Let's make a start. So yeah, welcome everyone. Thanks very much for coming tonight. If you haven't voted, this is recorded, so you can of course watch this tomorrow or whatever, and go and vote tonight. So yeah, who knows what's going to happen with it, but it seems that getting people out and voting is going to be a big thing tonight. Usual sort of blurb. We haven't got Shannon tonight. She's doing some other stuff tonight. But basically, as always, it's not legal advice. So yeah, and I'm going to say a little bit more about that in a minute because there's a couple of things happened this week in the comments which I just want to kind of clarify and whatever. What else? Oh yeah, no, so no personal data. So when you ask questions for various reasons, probably about I think about 7 or 8 reasons now, it's far better if you ask the question as if it's about someone else or a hypothetical person, or just a kind of a standard question which I can then copy and paste into the actual questions as we go. Just makes my life easier, but it also protects your privacy and actually probably helps you get a clearer answer. So that's why I say it. So it's not been difficult. If people put questions about themselves in the live chat, I'll just ask you to kind of rephrase it and start again. And as I say, I'm going to try and prioritize people who ask questions in a way which I can just quickly copy and paste it into the Word document in a minute because it just makes it easier. Yeah, cool. So I don't know if you've got any gossip this week, Will, but just a couple of LGO cases which I thought I'd let people know about. They're not kind of like groundbreaking ones, but there's one here about the Equality Act and the council's responsibility or requirement to make reasonable adjustments. And it was partially upheld. It was upheld on the Equality Act issue. I don't think either of these resulted in compensation payments, but the council had to do training. So I'm going to stick that first in the chat. And the other one is about again an quality issue around the council's requirement to do like large print documents basically, and the council kept getting it wrong. But again, I don't think there's any actual money kind of compensation. It was just a learning point really. But you could see how it would be kind of potentially much more significant if it was a more serious disability that was ignored. So I'm just trying to dig this other one out as well. You're gonna have to forgive me because I've only got one screen, so I'm trying to trying to do everything at once here. Um, yeah, cool. There's the other one. So yeah, there's two ones there. As I say, they're always worth reading out the LJ decisions because it's a great way to learn what the law is, because you just see cases in real time. And actually, probably say not just the ones which are upheld are worth reading, but the ones which are not upheld because you can see. I saw one of those cases. In fact, there's a bit where the guy said that he'd already supplied all the documents, and the LGO did the investigation, and they said, well, on the balance of probabilities, you didn't. So, and he might be, kind of cursing and stuff and saying, well, I definitely did. So there's this kind of whole issue about how you actually evidence stuff and how you get better outcomes by making sure you've got evidence, which is why it's so important to get subject access request stuff, which there are a couple of questions about on the list tonight. So yeah, I'm just kind of check. I've got just a notification there as well. So let's start a little bit more properly now. Let me in fact, there's a few more bits I want to say before we get into the Word document. So as I've said already, this is not legal advice, and I just want to explain just what it is we're trying to do here. So we wouldn't have to be here if councils followed the law, first thing. We also wouldn't have to be here if there was enough solicitors around legal aid funded to actually help people out. So that's why we're trying to give this information, is to try and be as helpful as possible, but it's not in any way a substitute for proper legal advice. Part of the reason for that is that, when you're in your personal situation and you've got some complicated stuff going on, you're kind of reporting to us in some very limited kind of character questions, kind of on a live stream, whatever. So it's very difficult for you to articulate the true nature of what's going on. Plus, you're going to potentially be kind of getting a few of the technical jargon sort of confused, which again is, it's understandable. It's a lot of confusing stuff in there. But what that means is when you ask a question, often we won't have a true understanding of what your situation is that we're then trying to answer. And that can lead to some unhelpful kind of confusion or whatever. So yeah, I think that's, kind of when you see us say something, we're specifically often kind of referring to the code of guidance, so you can go and find out for yourself what it is it actually says, rather than kind of saying, oh, some guys on YouTube said that I can go and give up this property and everything's going to be fine. That would be a rather kind of rash thing to do, and particularly if you've got competent professionals around you, don't be putting what we're saying on a YouTube live stream above, what your own support is saying. So just bear those kind of things in mind. As I say, it's quite difficult for us to kind of really kind of always understand what the situation is that someone's in. And so, yeah, there's just a really big caveat with what we're doing tonight. It's just there's kind of like that potential kind of errors we're going to make in giving answers. So anyway, having said that, let's get the oh man, this is hard on one screen. Let's get the Word document up and we'll start populating it with questions from the week. So question one, I've tried to group them a little bit. So question one is about basically subject access requests. There's a couple like this, so we're going to do them. They're quite straightforward answers, but they're interesting questions. So someone did a subject access request specifying the offices and the period requested, which is good. That's often what the subject access will ask you to do, is to basically say what information do you want. The council came back with an incomplete report. They didn't send anything subsequent to the date that the homeless assessment took place, despite several emails been exchanged since, including a complaint to the chief exec office. What is the procedure to retrieve the full information for the subject access request data when the council decide to withhold it? The person wants to know how their data and application have been treated. He's very concerned, especially after receiving an assessment stage somebody else's personal medical information by email from the housing officer. Thank you. So really good question. Really good to hear people are actually doing subject access requests, because it's probably one of the few things that you can kind of do which is always going to be a benefit to you. But it's not unusual for councils to not comply with the legal all the legal requirements. Basically, the timescales, it's very common for councils to basically go over the 30-day time limit. And it's very common for councils to withhold, either inadvertently or deliberately, some of the documents. And often you'll find that it's the documents they don't initially provide that are the ones which you really want. So I do think there is some bad faith going on in some councils where they deliberately don't give you stuff. In terms of what you do about it, is broken record, complain to the chief exec, another first stage complaint. So this person's already complained once to the chief exec, presumably about something to do with the homeless application. So you complain again to the chief exec, and this time you say, I made a subject access request. It's very clear from what I've got back that they haven't provided all the data. And you also put in that complaint that you've received someone else's data in the record. So obviously what the housing officer's done is they basically copy and pasted your someone else's PHP to become your PHP, and they've left someone else's data. That's very, very common. It's also very, very bad. It's potentially a serious breach. I remember getting one from Bedford, and the officer still works in Bedford, where there were the details of the entire family, details of a family fleeing domestic abuse, like what address they're in, kind of what happened to them and all that sort of stuff. Weirdly, if you went to complain to the ICO, which is the Information Commissioner's Office who regulate data protection stuff, as far as I know, this is what they said to me before, is they won't be able to actually take that aspect of the complaint unless the individual whose data was breached has actually comes to them themselves. So you might, if you've got contact details, if you really want to go over and above, is to basically contact the other person and say, look, I've received your data from the council, here's the email, if you want to complain, off you go. And it'll be pretty straightforward kind of complaint to go through. But anyway, yeah, so I've digressed slightly there. But yeah, so you want to complain to the chief exec about the fact that you haven't had all the data and someone else's data is in there. That hopefully will do the trick in terms of getting them to send the additional documents. There's a little bit of maybe I'm being paranoid, but if you list the documents you know exist, they'll just send you those ones. So you might be better just to say, I know for sure you haven't sent me everything, therefore I want you to do another search to provide all the data that hasn't been provided. And I've been in cases, for example, where you're doing subject access requests to multiple organizations, and you basically concede between the emails between the organizations that they haven't sent you everything. So you have one email from one organization that's not included in the other ones, and you can go back to them and kind of, that's evidence that it's not been done properly. If you have to go to stage two, then you have to go to stage two. The fact that you're including in it the fact that there's been a serious breach of someone else's data would probably sharpen their minds a little bit to actually respond to things properly the first time. But this is not an unusual situation. There is, so although most SARS should take 30 days, there is a little caveat which says that in exceptionally complicated cases, they can have an additional 2 months to respond. Which is not what's happened here. They just haven't provided the emails, but you will occasionally have those really kind of complicated. I've only had it once, but where you get those kind of an extension to the time limit. But I think that answers that question. Will, have you got anything to add to that one?
No, nothing to add to that.
Cool. And there was another question that came in on a similar note, which I'll just kind of pop up here. So So do you reckon the ICO, the Information Commissioner's Office, SARS service would accept no fixed abode? So again, I'm going to put this back into the chat here, this link, because the ICO has just started doing what could potentially be a really good service where you type in the kind of the organization you want to make a subject access request to, put in the email and stuff like that, and then you basically the ICO sends it for you. Now, when you fill in the form, I did this earlier actually. I'm going to try and do it live. Hold on a sec. So I did try the system out to see what it would do if you said you're NFA, and it does look like it's not that difficult to deal with. I mean, I've just put in the question. Bear with me. See if I can get the actual hyperlink from it. If not, I just hold on. I know how to do it. Oh, bear with me. So this will go in the live stream there. That's the link. And if we go on it, so if I just share my screen, and I'll hopefully be able to show this, we'll do all this together. So here's the link. So make it so you put in the name, Bedford Borough Council, you put in the DPO's email address. So if you search the organisation's privacy notice, there'll be about 10 different versions of it. But if you any one of them should have the data protection officer's email address on it, which will be dpo@bedford.gov.uk often. So you put that in there, you put in what information it is you want. I want all data from the housing department since 2020 or whatever it is you want to do. Keep it broad so you make sure you capture all the right information. There's no cost to you in terms of doing this stuff. So don't think, I better not ask for too much because it will cost me money. It's all free. This is kind of your right of access. But when you go down to here, so about you, so you put your date, your name, date of birth, that sort of thing. You put in, so it says here, the address is actually optional. So this is I'm just make sure. Yeah, this is about you. So this is your address is actually optional to do. So if you're NFA, you could put NFA on there, or you could put a care of address if you've got one. But I think by the look of it, that should be fine. But you will need to provide proof of ID down here, and it does ask you to kind of upload a file about proof of address. What you might do there is if you've got any previous correspondence with the address on it, put that on there. But just maybe write on it. Write on it in pen. I'm now NFA, this is my last address, scan it in, send it up. And I think the ICO would accept that, or they kind of see, they might come back and ask for some more information from you, but I think that would be enough. Bottom line is homeless people have a right to request records, so that it must be possible to do it. Cool. So let's get the screen back up. Will, if you can see what's going on in the live chat, I can't see everything at the same time. So, but we will come to the live chat as soon as possible.
There's just a little bit in there, but not a huge amount.
Okay, cool. That's good. Right. So next question, nice and easy one again, really. It comes up quite a lot because obviously councils don't do things in a kind of quick, in a kind of timely manner a lot of time. So could a decision come after 6 months? I'm assuming here what they're talking about is a Section 184, the final decision. And the answer is it shouldn't do. So we said, I'll say it again because it's important. You make a homeless application. As soon as the council as soon as the council is satisfied that you are homeless and you are eligible, the relief duty starts ticking, which is 56 days. And the statutory guidance, which is as good as legally binding, basically says councils should issue decisions on day 57, or if it's very complicated, another 3 weeks. So it would be very, very, it'd be almost impossible for a council not to have issued a Section 184 decision after 6 months. That would be a delay. That in itself would warrant compensation from the LGO. It's going to be my camera, so bear with me. Yeah, so hopefully that answers that question. Yeah, it shouldn't take that long, basically. And if it's taking more than that, if it's after day 57 of the relief period, if it was me, I'd just send a complaint into the chief exec just to hurry them up because it's important. So yeah, again, we'll just chip in if you've got anything else to add to it.
Well, only that, I mean, it could come after 6 months if they had to do some really complex inquiries, but as long as they're providing you with suitable temporary accommodation in the meantime, and they can explain why they've taken so long, that's okay. It's not okay, but it's lawful. But if it takes that long, something's gone wrong.
Yeah. It's far more likely it's just a delay rather than the case is exceptionally complicated. I mean, have you ever worked on cases, Will, that are that complicated that it takes that long? I mean, and if so, what sort of situations were they in?
Well, it's what's complicated is subjective, isn't it? And I had one. I regularly get delays on the part of local government, in homelessness cases where they say, "Oh, it's a very complicated case," and I have to write back sometimes. So I don't think it is. I mean, I had one. I had a Section 202 review this week where Southwark Council had been taking. I mean, they were supposed to complete the review in April, and they hadn't completed it by this week. And I said to them, I'm going to go to court, which if you don't do it on the basis you haven't done a review, and I'll give you till Friday. And then I was on Friday came and they hadn't done it. So I said, right, I'm going to court now. And they sent me a minded to letter, which we talked about last week. But I mean, that's just gone to sleep. So I mean, yeah, it is quite common. If you don't press them, it's not unusual for things to it's not unheard of. I'd have to say it is unusual for it to take 6 months, but um, files go to sleep in cabinets sometimes.
Yeah. Cool. So next question. Again, it's a pretty short answer because there's a video about it. So can you trigger a homeless application through a phone call to the council homeless team? You absolutely can. However, you absolutely don't want to do that because you want to have it all in writing. It's a legal process, and kind of think of it as anything you can say can be used against you. That's not the way the law works, but that's kind of how you can think of it. So the council can twist what you've said. They can deny you've said stuff. And kind of just, kind of have an argument with them about it, and it doesn't get anywhere. So you always want to basically do it via email. That's the only way I'd suggest doing it. If I was homeless, I would never do it any other way because you've then got a record of you sending it. So it's not the same thing as using an online form where you just click a button and it just vanishes. You're sending it via email, therefore you are, you've got that record, and I'd be copying in other councillors and politicians as well at the same time, because then you've got maximum kind of visibility, and therefore it's harder for the council to gatekeep you. And the link here, I'll put it into the live stream chat if you want to see it. Is it's just a video I did a few months ago about the best way to do it, and I'll probably go through about 10 different points about things I would do if I was in that situation to make sure the council maximise the chance of getting a fair hearing. So that's that one.
Can I just
This
add
one's
to that a little tiny bit to that one?
yeah, go for it, mate.
The question makes the perhaps dangerous assumption that somebody will answer the phone call, which cannot be taken for granted. It's not unusual for councils to give numbers which don't get answered. And if I can I'll put a link in the chat. The Inside Housing have done a really interesting bit of research as to how easy it is to make applications to local authorities. My suspicions that I've mentioned in the past on this show, that since COVID, they've often sort of pretended it's still happening. So they've abandoned what used to be called homeless persons units, where you could go in and wait and hopefully see somebody, and they're making you go to libraries or other places. And then some councils have said we only do a telephone service, which is very dangerous if no one's answering it. So what I'm going to try and do is I'll try and draw the best way to make a homeless application, I think, is by email. I mean, obviously, if you want an urgent response, it's a bit like putting a message in a bottle, but at least you've got a record there that you sent it. And if it hasn't bounced back and that's the right address, nobody can say, well, you didn't, we've got no record of that, which is the danger. So I would say send an email, but I'm going to try and make it. The problem is if you go to most homeless persons' websites, it's only a minority of them, I think, that will actually give you an email address. Some of them will give you a form to fill in online, which, as Mike said before, is not that reliable because you don't know where that's going and you may not be able to prove that you sent that. So I'll try and publish a list of all the addresses, and it's the same if you want to try and get help from. I'm not people probably don't, but people try and get help from children's services. Very difficult to do, and for lawyers, if you want to try and get hold of a local authority legal department, I mean that they don't put addresses anywhere. You have to sort of hunt them out or just find them from somebody else who's managed to get through before. So it is really difficult. The bottom line there is there's communications problems, which mean that phone calls may not even be a good way to speak. So, or you won't get to speak to anyone.
Yep.
That's it.
Yeah, cool. I mean, and you mentioned that, Will. So I'd say as well, like, if you generally can't find an email address for the housing or the housing advice, whatever, email address, you can always find the name of the councillors, and if you look on the council's website, it will basically state, first of all, like which councillors cover which area, but also which councillors are in charge of or overseeing housing. So they're not in charge of it; they're overseeing it. And they'll also always have their councillor's email address on the website. So as a backup plan, you can send an email to the councillor and say, this is a homeless application. And you start it by saying, I can't find the email address on the council's website for the housing team. Can you forward it on? And as you say, I would strongly argue that would in itself trigger a homeless application, because you've alerted a department of the local authority, even though it's not the housing team, and which kind of gets the ball rolling. And a lot of councillors are great. So, some councillors are great. So you can kind of get somewhere doing that way as well. Question number 5. So in your complaints, so this kind of builds on some stuff we've done in the last couple of weeks. So it's another good question. So in your complaints, can you tell the council to work out your compensations themselves, or the local government? The LGO can do it by themselves. Asking for a figure might sound rude or greedy. So it might seem that it's kind of greedy to ask for money about homelessness, but I would just say kind of it's really important just to look afresh at what's happening here. The council's rude and greedy, or maybe not greedy, but they're rude in kind of not housing you when there's a legal duty to do so. And you're absolutely, in one sense, if you complain to the council and they uphold it, if you haven't asked for money, it's very unlikely they're going to offer it. So I would say you would want to raise that kind of, that figure. You go to the local government ombudsman's website in terms of the remedies guidance one. In fact, again, I'll just kind of put that onto I'll try and put it, if I'm competent enough to do it, I'll put that link into the live chat as well. So again, there's just that kind of, the LGO does that guidance on how much you should be asking for. Now you can wait for it to go through to the LGO, and they'll do the same maths that you will, but it just seems to me to be a better way of doing it. If you're saying from day one you failed, and therefore according to the LGO you should pay me this amount of money, I think they're going to be far more likely to take that seriously and actually treat that as they should do, because they're immediately going to see, okay, this is someone who's a little bit savvy. They kind of know, they realise that there's been a fault here that could lead to a compensation payout, or remedy payout. Technically, it's not technically compensation, but it's not greedy. And if you ask for £1 million or something, then yeah, that would be greedy. But it's it's not rude to you shouldn't have to apologize for or justify asking for the council to treat you according to your rights. I think as a society, we've kind of, a lot of people I think feel like that, and I just think it's just something we need to kind of push to change, because yeah, we've got a rights-based law system. It's good. It's a good thing. People fought for it. People, went to a lot of trouble to make housing law really good, and other areas of law. It would just seem a bit strange just to kind of let that kind of go and not kind of fight for your own interest and the interest of your family. So yeah, so I'd say yeah, it's not rude or greedy. Don't as long as you're not calling them names or anything, just to kind of lay out. The classic example at the moment is, I've got kids and you've had me in B&B for more than 6 weeks, and therefore the LGO recommends £200 per week. So I'm going to ask for £200 per week. That's not rude or greedy to do that. It's there to kind of recognise that the injustice that they've caused you by choosing not to house you in suitable accommodation. And it is a choice. It is a lifestyle choice for them in terms of, kind of not following the law. They could do a lot to change the law, change their own practice, but they don't. And I know there's going to be one person who gives me a thumbs down for that, saying that, but I'm quite happy with that. So yeah, cool. Where are we up to? Here we go. So next question. Oh yeah, again, we'll just butt in if you want to add anything to that.
Sure. But I don't.
I've
said my bit on that one.
Cool. Yeah. So next question: can a council only give you 3 days to make a new medical application, filling questionnaire, and providing up-to-date medical evidence, and expect you to make it all in one PDF when you have no access to a computer, the skills to do it? Is this a form of gatekeeping? Person only has a mobile smartphone, all paperwork in storage as in a hotel. So yeah. I mean, when it comes to this question of reasonableness, I guess, yeah, well, you might kind of give a slightly different slant as a legal perspective, but the word reasonable just means what a reasonable person, a reasonable Joe Bloggs would expect. And clearly it's not reasonable to expect someone who's homeless, who's got their documents in storage, who's only got a mobile phone that can't do PDF, save things as PDFs. That's not reasonable to do. If it takes the council at least 56 days to make these inquiries and issue a decision, then it's, that's the sort of timescale you're looking at, and they should be able to help you out with that kind of stuff. So I guess that question, I don't think there's any sort of law that says, what a reasonable timescale would be. but I think any sound, sane person would look at that and say that's not reasonable, and that's kind of the answer, really. It's not reasonable to do that. And yes, I guess in that sense, whether it's a form of gate, I mean, I guess it is a kind of a, it's a form of maladministration. I say whether it's technically gatekeeping, I don't know. But what it's really doing is, they're setting you up to then not be able to provide the medical evidence within 3 days. And then the council says, well, you've not provided it, therefore you're not in priority need, or, it's not relevant, or, they'll give you a negative decision. So what in terms of what you should do, again, I would maybe email your counsellor and say, look, I'm getting help from the council. They've asked me to do this within 3 days. I can't do it. Can you help me out? Can you ask them to give me a bit more time? Involving council, it seems it does vary from council to council, but council staff do tend to be terrified of councillors asking questions. They kind of run around and sort of panic when a councillor asks a question to a team, even when the council's not done anything wrong. So do involve councillors as much as possible, and that has that knock-on effect down the line of improving services, because it increases that transparency of what's really going on within councils. So yeah, again, Will, you might again, have you got a different answer to that?
Very quick one is obviously they can do it, and it sounds like they have done it in this case. But the question is my answer is that any decision which referred to that process and justified the decision based on it, such as we've decided you're not vulnerable because we gave you 3 days to do this and you didn't do it, would be completely unlawful. And it's unlawful again for the same old reason I keep going on about. It's not for the applicant to provide medical evidence. It may be with a housing register application. If you're saying I should be in a higher band because I've got a medical condition, they may say, well, give us some evidence. But if it's a homelessness application and you want accommodation, say that if you say I'm in priority need and I'm vulnerable, I've got a medical condition, that should be enough to give them reason to believe, unless they have reason to doubt your bone, if they think you're lying. So they should do that, and they shouldn't be asking you to provide this evidence. They should be making inquiries. So they should say, well, okay, we'll put you in temporary accommodation and tell us what your problems are, and who can we get confirmation from this about, and we'll contact them. So they're doing it completely the wrong way around. And if they went to court and said, well, we gave the guy 3 days or the woman to do this, the judge would throw the book at them.
Cool. Yeah. So thanks, Will. I'm just there's actually some more questions that came in through the week, but now we've exhausted the ones that were written anonymized. So we're going to, as I say, I'm going to try and prioritize the ones that have been kind of anonymized, which makes my life easier. So we're going to go to the live chat, and then once we've done them, we'll come back to the ones that come in through the week. So we've got one here. So friends in this section 202 suitability review waiting for a minded to letter. If the review is rejected, can we go to court? So again, Will, do you want to answer this one? Because
the
answer
very
is
quickly,
yes, but
yes. And the procedure where you do it by, which I was just mentioning earlier, is an appeal to the county court under section 204 of the Housing Act 1996. And you can do that by filling in an appellant's notice and emailing it to the court. I mean, there have been judges who've, in my opinion, said silly things about people being expected to do this on their own. It really is quite difficult, and you need a lawyer. You should get a lawyer to do it. But if you can't, then if you do a Google search for homelessness appeal, you hopefully come up with an appellant's notice, and you just fill that in and say what's wrong, and they should issue it. But yes, you can. And if they don't complete a review within 8 weeks, you can then appeal on the basis that they failed to carry out a review, because it says that they've got to do it within 8 weeks, and then you can appeal within 21. You've got 21 days from the date of the negative decision to appeal, and it's the date of the decision or when they should have reached the decision. So yes, I hope that answers your question.
Yeah, I mean, it might be a topic for us to go into a bit more detail. So in my casework, I never got that far. I always got it resolved at the 202 stage, and that was with a combination of kind of arguing the case and also complaining when council staff were being stupid, basically. So I've never done it myself, and neither of us done it as a lay person. So it's maybe worth us doing a bit more of an expanded one
Yeah, I
about.
think it would
Okay,
be good. Maybe we
yeah,
could do a video about how to do it yourself if you can't get a lawyer.
yeah. Like if you really, I mean, yeah, route one is always going to be to get a lawyer, but if you genuinely can't, then
Mm.
there's obviously a way of doing it. Um, So next question is coming through the live stream here. So for a friend, if a multi-disabled family with main disability, wheelchair, crutches, etc., is in unsuitable social housing in area, but longs to move to another area but has difficulties, no connections, what options or advice would you give if possible, please? So it's a good question. Okay, so I guess this is an interesting one. So I'll give the kind of what I would consider to be the straightforward legal answer here, and then but there might be a little bit more to it. So you could make an argument that although you are accommodated, it's not accommodation that's reasonable to continue to occupy indefinitely, and that would make you legally homeless under Part 7 of the Housing Act. And what that means is, you can make a homeless application to a local authority, and technically you can approach any council in the country. There's nothing stopping you doing that. The difficulty is that um, in a very short space of time, that council is going to refer you back to the area where you do have a local connection, unless it's unsafe for some reason. So domestic abuse with the classic one, if you're subject to domestic abuse, you can go anywhere in the country, and they can't refer you back to your home area if there's any risk to you. But if it's if it's something less than there's a danger to you of some sort, then first of all, if you try to apply directly to Part 6, the housing register in another local authority, you get knocked back at the first stage. And really, realistically, although you would get a bit further in terms of, legally speaking, the other council should accept the homeless application. They should start the not start the relief duty, but they should do the assessment and the personalised housing plan, and technically house you in Section 188 accommodation. But that's a pie in the sky right now, to be honest. And once they've done those things, so you've then got a PHP, you've then had an assessment, they should then refer you back to your home area. So I don't think that really helps the person in this situation. The other thing, which I've not got any experience of at all, would be a trans or kind of what's it called, like a home swap or like a exchange. I have never seen an exchange happen in real life. Whether there's other councils in the country that do it a lot, I don't know. The problem with exchanges is people who want to exchange want to generally exchange for a good reason, as in they've got horrendous neighbours. And so, you're trying to swap out of a property where it's horrible, and that's the reason you're trying to swap out of it. It's going to make it very difficult for someone else to, not impossible, but for someone else to want to actually come to that property. So, plus, I think the admin involved and the bureaucracy involved just makes it. I think it's something that housing associations just don't want to do because it's just too much work and they lose money through the voids and stuff. So, yeah, I don't know. I mean that's my answer. It's not a good news one, but I think it's going to be very difficult to get anywhere with that one. Will, do you want to add
Well,
anything
I'd,
to
I'd
it?
have to agree with you that local connection is a really tough one because you're up against local authorities that really don't. I mean, we talk about gatekeeping, but they don't want to take people from other areas, and finding that they've got no local connection and they can send them somewhere else is a marvelous opportunity to just pull the plug on the application. And the rules are really strict. I mean, if you haven't lived in an area and you haven't got close family there, I mean, there's about half a dozen different ways you can get local connection. Remember that if you're at risk of abuse, if you've experienced or you're at risk of violence in the area where you live, then you where you have a local connection, then you can apply to any other area. I was dealing with a case this week where somebody was about it's tragic because they were living in Authority A when they had no recourse to public funds. They then got put in Home Office accommodation for 2 years. And then when they came out of the Home Office accommodation, they then had a local connection with that area, but they wanted to go back to where they were before. And they would have had a local connection if they'd been there for 3 years out of the last 5 years. But they were only about 2 weeks, they were just 2 weeks short. And it's really sad because the daughter's at school in the first area still, and she's really happy there. And I had to advise them, like, they're going to fight this, they're not going to accept it. What you could do is get a job in the area, because once you're employed there, you've got a local connection. And as long as it's not a sort of joke job or casual labor and it's genuine, you'd almost have a connection straight away, I think. But other than that, you're really stuck. You've really just got to try and stay there for 6 months, which obviously if you're not going to be able to do that, and you'd have to give up accommodation and take the risk of being found intentionally homeless. So I'm really sorry, I can't hold out a lot of hope on local connection.
So, and just bouncing off something we all said there. So within, I don't know about Part 6. So local connection, that term is used under both Part 6 and Part 7 of the Housing Act, and they mean two different things. But under Part 7, so if you're homeless, also volunteering would count as local connection. There's a case on it which is quite an interesting one. It was Ealing, I think it was like Fox v Ealing or something, and basically the judge said, yeah, if you were volunteering in an area, then that would count as local connection. The thing was, in this case, was he wasn't actually volunteering. But if a lot of organizations you can volunteer for, which involves kind of some sort of sign up process and some sort of contracts and stuff between you, even though you're not technically you're not getting paid, but there's employment law still counts within volunteering roles, I think, unless it's kind of really sketchy volunteering. But if it's for a reputable organization, it would also count towards local connection. Not that I think that's going to help this particular family, unfortunately, but it's just something that might help someone else. Yeah, sorry, we can't be more constructive about that one. Next question: family faces homelessness. Section 21 has elapsed. The landlord raised the rent by 50%. Housing officers won't help until the possession order. Should they wait for court, or should the housing officer be doing more now? So me and Will were actually talking about this a little bit before the live stream tonight. So chapter 6 of the Code of Guidance, and I've done a video about this, so I'll dig out the video and kind of stick it in the chat. But the chapter 6, which is the definition of homelessness, basically makes the point that it's in fact, let's just get it up, because otherwise, yeah, just so you can kind of follow our thinking here. So where are we up to? Here we go. So we're going to come back to this bit here in chapter 9, but if we just go to 6.35, I think, something around there. Right, yeah, so 6.35, and just to reiterate, although it's called guidance, it's statutory guidance, so it's basically telling councils how to interpret the law. So it's weighty document, it's a good document. The Secretary of State considers that where an applicant is an assured short hold tenancy, a tenant who has received a valid notice under Section 21, and the housing authority is satisfied the landlord intends to seek possession, and further efforts from the housing authority to resolve the situation and persuade the landlord to allow the tenant to remain in the property are unlikely to be successful, and there would be no defence to an application for a possession order, then it is unlikely to be reasonable for the applicant to continue to occupy beyond the expiry of the valid Section 21 notice. Now, this term here, reasonable to continue to occupy, is absolutely key, because that is it just means legally homeless. If you've got accommodation but it's not reasonable to continue to occupy, you are already legally homeless. So what that means is, if you go back to Section 108 of the Housing Act, 1996, it basically says if there's reason to believe that you might be homeless, might be eligible, might be in priority need, then the interim duty kicks in there and then. And it's something which councils get away with all the time, not doing that. But there are, I might have to dig out an LGO decision where they kind of actually say this, and they actually, kind of, the council has to pay compensation because they basically advise the person to stay put. Now, you can stay put, you've got a legal right to stay put, and there are some benefits in staying put, because if you can stay put for a month or two and that's enough time to get somewhere else, then that's probably a very good outcome. But yeah, but councils can't tell you, wait till the bailiffs. And I know the question here is talking about waiting for the possession order, but this is this is what the law says. So, and again, if you can obviously pause this and read the additional stuff there. I think it kind of says what I just kind of said there about kind of staying put if there's a good reason to. It then goes on to say 6.36, the Secretary of State considers that it's highly unlikely to be reasonable for the applicant to continue to occupy beyond the date on which the court has ordered them to leave the property and give possession to the landlord. So highly unlikely. So the first one's unlikely, this is highly unlikely. And then it says housing authority should consider it reasonable for an applicant to remain in occupation up until the point at which the court issues a warrant or writ to enforce the order of possession, which I think in layman's terms, is that a bailiff warrant, Will? Yeah, cool. And then it says in big bold letters with underlining, housing authority should ensure homeless families and vulnerable individuals who are owed Section 108 interim accommodation duty or the main housing duty are not evicted through the enforcement of an order for possession as a result of a failure by the authority to make suitable accommodation available to them. So councils across the land right now are just getting away with not doing this stuff. I'm pretty sure. Oh man, I'll dig the video out from the YouTube channel. It's called something like "Do I Have to Wait?" It's got bailiffs in the title. If you search for the term bailiffs on the channel, you'll find it. But I'm just gonna I'll dig it out and just put it up on the thing. I'm pretty sure if I'm going to find it, I think there's some LGO. I quoted some LGO cases in the description, which basically you can see for yourself how the LGO considered it. I'm just trying to find it now. Here we are. Yeah. So I'll put them both. I'll put them both into the live chat now. No, do you know what? I'm not. That's the easy way of doing it. It's just if I put the video in it itself. And so if you go to this video, if you click on this link in the live chat now, you'll get the video, and on the top of the video description is the two cases. So have a look at that. So yeah. Cool. So how are we up to? So I think, yeah, have we got anything more to say on that one, Will?
No, I mean, the only thing I was slightly worried about with the question is that if the landlords put the rent up, even though the Section 21 notice is expired, it sounds like the landlord may not want them to leave, or may not require them to leave, because you wouldn't bother putting the rent up if you were going to kick someone out. So the council may say, well, there you go, we've got reason to believe the landlord wants them to stay. But then again, if the landlord's put the rent up, it may make it unaffordable, and you could say you're homeless then. The main problem with these cases is that it's very difficult unless you get a lawyer and you can go to court. And even then, it takes a long time to get a case off the ground. And a judge is probably going to say, are you really here because you want me to order them to house you a week earlier than they would otherwise have to? But I think the secret is to just keep complaining. And then if they actually say we're not going to do this anymore, maybe they'll stop doing it. But the problem is, even if they uphold a complaint and say we'll make sure all staff know not to evict, to tell people to wait for the bailiff's warrant, there's no guarantee that they will won't go on doing it. And so it's a tricky one, that.
Yeah, I would say for professionals who work in an area, this is something you want to be taken up with your publicly with the council. So I know, so John John and Katie in Just Us in Bedford are basically they're haranguing the council about this issue, and they basically just keep going on about it. They keep complaining to the head of service and telling her when it's been done again, and kind of raising it in that kind of public setting, and it kind of hopefully will lead to a reduction in it happening again. So yeah, there might be a bit more to say about that. In fact, let's introduce a bit of complication here. So as I say, this is the bit that me and Will were talking about before we started today, which again for the Code of Guidance, except this time it's chapter 9. I've been
intentional homelessness, yeah.
Yeah. So so both homelessness and intentional homelessness all pivot on this idea of whether it's reasonable to continue to occupy. And I think it was 9.24, I think. So basically, and there's another question that came in the week that was kind of worded slightly differently, but essentially it was the same kind of question. So try to make sure I get the right bit. So yeah, no, sorry, 9.24. So general example of an act made in good faith would be a situation where someone gave up possession of accommodation in the belief that they had no legal right to occupy, to continue to occupy the accommodation, and therefore it would not be reasonable for them to continue to occupy it. This could apply where someone leaves rented accommodation in the private rent sector, having received a valid notice to quit, or notice that the assured short hold tenancy has come to an end and the landlord requires possession of the property, and the former tenant was genuinely unaware that they had a right to remain until the court granted an order for possession and a warrant or writ for possession to enforce it. That's a bit of a mouthful, but obviously you can see it on the screen, so you can kind of read that yourself. Now, my hunch, and I've only kind of come across this today, but my hunch about this is that this is basically an artifact. This is an old bit of guidance, and it's been it predates the bit in the chapter 6 that we just read. For those who subscribe to the channel, you'll notice that I'm basically doing an audio book of this code of guidance for the people who just want to have it on in the background and stuff. But I've noticed, for the first time having read it out aloud, I've noticed there are a number of things like typos, but also internal inconsistencies in the guidance. And I think it's just because this guidance has basically been written over many years, gets amended here and there. And ultimately, I would say the HRA, the Homelessness Reduction Act, when this was last kind of amended wholesale, was just quite a bit of a bit chaotic. So I think that this sort of stuff is just inconsistent for that reason. So have a look at those LGO decisions that's in that video I was just talking about. I'm going to have a little dig around in a textbook this week just to see what it kind of how it reconciles these two things. They're not technically polar opposite here, but what it's basically saying is if a housing officer said to you, "Oh, you've got a legal right to occupy," then that would not be an act in good faith because then you know better. And so I think that's probably what a housing officer would probably focus on this paragraph and say, you would be intentionally homeless if you left it. Whereas, as I say, the LGO and Chapter 6 would both say that's not the case at all. It's not reasonable to continue to occupy past the expiry of the valid notice. So again, once I've found a better answer than that, I'll do a video about it or something. We'll talk about it next week in the live stream just to give a bit more clarity. But as I say, that's the nature of the law. Sometimes it isn't particularly clear, unfortunately. So, and again, yeah, I'll there's some other resources as well that I might kind of have a look at as well to find out. Anyway, so where are we up to? Yeah, sorry, we haven't mentioned this one yet. So a friend in supported living is very unhappy due to being around antisocial behaviour, and she's poor health. Can she ask the council to move her into another temporary accommodation if she has no priority need? So again, I think we're talking about supported living here. I would call that supported accommodation because for me, supported living is something or somewhere where often social services will place someone who maybe has a learning difficulty or something. So it's done under the law rather than just being a charity or something that's kind of doing a hostel. It's a very common situation, very sad situation. It's one of the many reasons I really dislike supported accommodation because you just basically put in loads of people with lots of different problems all in one building and thinking that that's going to be cheaper. It's not cheaper. It's horrible. But I tell you a couple of things that can work that we've seen work in Bedford. So one thing we've seen is that in this situation, you'd effectively make the argument that although this person has a legal right to occupy the supported living, actually it's not reasonable to continue to occupy there because of the impact it's having on their health. Now that's a very difficult argument to make, but you can do it. But really, you're going to need a letter from a psychiatrist, which basically evidences that it's having that impact on you. It's a high threshold type thing, which is not indicated in this question. So I don't know that you could kind of, make the council follow the law and house you. I think you can always ask the council for help and say, look, this is the situation. Can you recommend something? And they might just give you the details of another supported accommodation unit in the town or something. But that might be better than nothing. Supported accommodation, you don't need to be referred to generally by a council. You can generally self-refer. There are exceptions to that, but generally you can do it yourself and you've got choice. Some supported accommodation has no local connection criteria on it at all, so you can basically move somewhere else completely. But there's caveats with it. By accepting supported accommodation, first of all, it's not very secure. So there's a chance you get evicted for something stupid, and you might then be intentionally homeless, and you might also be stuck there because you might not actually get any kind of move on option. Really, they might tell you that you'll get social housing after 2 years, but actually that's just nonsense. They lie. So yeah, I think that so not being in priority need is one of the big issues there. I think this person would potentially both not be homeless and not be in priority needs, which basically immediately means that the Part 7 Housing Act stuff is not going to kick in at all. You could still apply for social housing under Part 6, depending on their local policy. And some supported accommodation has a particular thing saying, if you live here for 6 months or 12 months, you'll get band B or band silver or whatever. But you just got to check out the local policy there because it's different everywhere. So yeah, Will, have you got anything to add to that one?
No, other than the fact that it's just a question of how bad the antisocial behavior is and how poor the health is. And the worse they both are, the more chance the person has of being housed, unfortunately. Because if the antisocial behavior involves a threat of violence towards that person, of course, then they're entitled to say they're homeless. And arguably, um, if the conditions are such that the health condition, it says she's got poor health. So if her health is sufficiently poor that she would suffer greater harm if she became homeless than somebody in good health, she's okay. And again, if the antisocial behavior is on the part of anybody who is associated with her, as like she's been in a relationship with, and it amounts to abuse, then she'd have priority need and she'd be homeless. So there are some avenues, but it's difficult to know on those limited facts or limited accounts what the actual where she fits on the sort of diagram, as it were.
I think there's a lot of people in this situation where you've got, drug
Yeah.
dealers kind of active in the block, and fights, and all sorts of other stuff happening. And everyone kind of knows it's horrible, but because homeless people don't tend to be treated like humans, they kind of just, oh well, that must be all right for you then, sort of thing. When actually most reasonable people would not want to live in those sorts of environments. There's just an addition to that previous question. So this going back to this kind of section 21. So the family are in band B across multiple areas and seen as in need and vulnerable. So and again, this is a good question. It's just to kind of make the point. So this is a good example of where specific words mean specific things. So in need, in need would maybe make me think that maybe some of the children are child in need, so they might have a disability or something. Vulnerable is something which means something, if you're effectively, if you're a single person under housing law, so you wouldn't need to apply it to a family because you're already in priority need if you've got dependent children. So again, but vulnerable within this context might mean some sort of contact with adult services, adult social services. So yeah, again, this isn't, I'm just kind of flagging these terms can mean different things. It might be difficult for us to make sense of it. But so if you ban B across multiple areas already, the question would be, what are the average waiting times for those areas? And you can FOI that. So you can ask the council, can you provide average waiting times for people in band B with a need for a 3-bed accommodation or whatever your bedroom need is? And that might give you a bit of information about where you're likely to, which areas likely to come up first. But ultimately, it seems certain to me that you are going to be owed the interim accommodation duty. If once the council accepts that you are in fact homeless, and for example, if they accept the relief duty, they are by definition saying that you're already homeless. So they should also be providing interim accommodation. Yeah. So yeah. The other and this is again, this isn't good news. Something else to check in the small print of those different areas that you're in. So just to make the point again, the housing register policy is different in every area. And some areas, they would say that, you're in band B, you're sitting there nicely, but then you become homeless, then you move into temporary accommodation, and you basically drop down the banding because they just consider things different in the areas. Some areas are fine. So you also just want to basically check out those different areas to have a look at the housing allocation scheme. That's the technical term. So if you Google the council's name, housing allocation scheme, and have a look at the banding and just have a look at how the policy works. Because some people who are, they've applied for social housing already, everything's good. They then become homeless. They effectively drop down the banding quite considerably. Plus, they'll get a new effective date on their banding. So they would basically lose priority that way as well. So these are all things which we can't give you any definites about, but it's hopefully something that you can kind of go flag up and have a look at just to work out what's going to happen with your applications. There's some more questions coming, and I just need to make the time with some other stuff as well. Bear with me. Hey, you right, Andrew? So I shall be able to find this out. Hold on. So right. Okay, nearly there. Sorry, guys. This one here. This is the question that comes from this one here. So hold on. Don't do that. Here we go. So antisocial issues and fire hazard, they have one access communal area that is often blocked or fire entrance exit door. The property is the kind of social housing nobody will take unless desperate. So this is we're going back to the person who potentially is looking to move to another area. In terms of fire hazard type stuff, I've not got any experience of it at all. What point does having no fire exits when there should be one, at what point does that become a big issue for environmental health or whatever to actually step in and do something?
I'm sorry, I've never got involved in cases involving that. But I'd have thought that if they are living in a property that is deemed to be a fire hazard, then that would be a reason for it not being reasonable to continue to occupy. I mean,
I know there's a lot of kind of where you get sort of shady landlords and HMOs. So councils kind of come across this sort of thing quite a lot. However, again, maybe this is maybe a question for me to take away this week and do a little research on, just to find out, at what point can you actually make the council do stuff? Because certainly councils don't do what they should already know they should do in terms of, category one hazards or whatever, and they know they should be accepting someone's homeless. But I don't know. Yeah, again, give us a week on that one. I'm gonna make a note and we'll come back with that. In fact, I'm gonna highlight it just so I can actually remember. Otherwise I'll forget. So yeah. So hopefully we'll have a better answer for you next week.
We've done that one. The next
Yeah.
one.
So okay, just something about local connection.
Done that.
Oh yeah, sorry, no, Andrew. Yeah. Hold on. Yeah, I'm with you. I've caught up. So, local connection follow-up. If client has no local connection to any specific area because lived in multiple areas or traveller lifestyle, does the first council apply to have to take the responsibility? So effectively, any council that you apply to has to take the responsibility. So I think in chapter 10 of the Code of Guidance, I think it even makes that point. And again, let's go find it just so we can, kind of get it from the horse's mouth, so to speak. So it's 10.5-ish. So so this here is the part 7 definition of local connection. And you'll notice, it would be quite unusual, but it would be possible to have no local connection anywhere under these things. Because bear in mind, you might have family somewhere, but if you go down a little bit, 10.9, it basically makes the point here: a housing authority should not identify local connection through family association with an area other than the one where the applicant positively wants to live. So you might have a brother in the next area, but you might hate his guts. That's not a local connection. The council can't refer you there. But I'm just trying to work out if there is anything which specifically says about. So, this would potentially apply 10.6 in the case of a person who's street homeless or insecurely accommodated, which I don't know would be the same thing as living in a traveller lifestyle, but it's not, there's similarities there. Essentially, wherever you are, you've got local connection, really, if you've been residing in that area. So, evidence for that might be that you're engaging with local services or you're registered with a GP or something. But again, it's not prescriptive. Yeah, so again, they have changed this. I don't know when they changed it, but it used to be a little bit kind of easier to have no local connection anywhere. In which case, yeah, you can go anywhere you want. And if we go to 18.9-ish, you can make multiple simultaneous homeless applications. Yeah, so here, applications to more than one housing authority. I'm not going to read it all out. You can pause it and have a look for yourself. But you can, if you had no local connection anyway, you could apply to 10 different councils on the same day and basically take your pick. You need to be honest that you're doing that if they ask. And it's then down to the councils. They'll argue about who's going to take responsibility. It's not a terribly good idea, in my opinion, to do it that way, but it is legally possible. So, yeah. Did I answer the question? I feel like I did. I feel that was at least some of an answer. So let's keep going down. Right, there's a question there. They want to. Am I missing something? Oh yeah. So okay. So there's more to this question here. So right. I don't know what a section 13 is. What's a
No,
section 13?
I thought I was missing something. I don't know what it is either. Perhaps
Yeah.
person could put it in the chat. What section 13 of which act?
Yeah. And again, I'm just going to add this one in. So this is. Oh, hang on a minute. Which question was it? Sorry, I'm losing track. Bear with me. So question is the band B in multiple areas question. Where's that gone? I've now can't see it. Oh, here we go. Yeah, this one here. So it's an addition here. So we've got this bit here. So they want to leave saying they're trying. Yeah, so we need to know what section 13 is. I don't know what that is. And then there's another bit to this question saying, oh, it's just saying thank you. Okay, cool. No worries. Yeah, so I think that's when we find out what section 13 is, we'll kind of answer that question.
Oh, section 8. There we go. We got it.
Oh, section 8.
Those are rent arrears based possession grounds, I think.
Yeah, you don't want to try for a section 8. That's not I would understand section 8 as being a fault eviction where you've done something wrong.
It's
so I
where
don't
you've
know.
got more than 2 months rent arrears.
Yeah, okay. Yeah, so again, if you just rephrase that question in, because I still don't. Yeah,
I think it was.
Oh no, so
It goes back
So
to one about the
maybe the
Section
landlord's trying
21
for
notice,
section. Yeah, I
wasn't
don't
it?
know.
Earlier on,
Sorry.
it was the landlord had put the rent up. Hang on. Yes, it was the Section 21 that had elapsed, and I said, "Well, why? How come the landlord's put the rent up if he doesn't if he wants them out?" And
So when it says they mean the landlord's trying for a section 8. That's maybe what we're talking about here.
yes, I think they're hedging their bets and thinking, "Well, if I can't get him out under Section 21, maybe they've discovered." Because sometimes landlords will serve a Section 21 notice and they'll go to a lawyer or something, and the lawyer will say, "Well, did you protect their deposit or something like that?" And they'll say, "Oh, no, I didn't." And I say, "Well, don't bother applying under Section 21 because you're not going to get it. You'd be better off putting the rent up." Yeah, that's probably what's going on.
So that would potentially have the benefit that would mean it may well be that you're now not able to genuinely afford your rent, which means you're not going to be intentionally homeless. So you can be evicted under Section 8 and still not be intentionally homeless. It's not the same. It's not the same thing. Basically, it's related, obviously, but it's not the same.
And also,
Um,
if you are going to, if you do get a rent increase like that, do go to the council and make a homeless application on the basis that it's unaffordable. Because then, if you do go back, they can accept a prevention duty, try and help you stay there. And if they come up with nothing and say, "We're really sorry, but we can't come up with anything. It's not suitable. You can't be expected to live there," you've got a fairly good guarantee they can't find you intentionally homeless later.
cool. Okay. Um, I didn't listen to what you just said, Will, but I'm sure it's great. I was just
Sorry.
trying to. No, that's cool. I'm trying to keep
This
up
is
with what we're
good.
up to. We need Shannon
Yeah,
here as well, just to keep us
I
on
think
track. So okay, right. I think this is a
I hope
continuation
somebody
from another
listens.
question, but it's standalone. So for a friend, if a disabled family has difficulty presenting their case and applying for housing, do the council have a duty to help with the application, or will a CAB lawyer be able to qualify to help? So yeah, so if you go back to the start of the session, the LGO cases that I put on there, they were actually about this kind of thing. So basically, what the LGO cases said is that councils have an anticipatory duty under the Equality Act to basically to expect people with disabilities to come to them for help, because often disabilities are going to lead someone to being homeless. And then it makes the point, and it's interesting it made the point here because I've had a case where the LGO didn't uphold this point, but it says it in this case where essentially you don't actually have to tell the council that you have a disability for them to have a duty to kind of anticipate your needs and kind of make adjustments. So read the text of the LGO cases there, but essentially so and I don't care how clever you are or whatever, you want to get an advocate or you want to get a lawyer involved if you're homeless. It's just almost impossible to try and expect someone to get their head round the law and then fight gatekeeping officers as well. So CAB, if they don't have a specialist housing person in their team, they would probably be able to kind of refer you to someone who is qualified in the area. Some areas have no legal aid funded housing solicitors at all. So the whole of East Anglia hardly has any legal aid funded housing solicitors, as an example. Somerset and Dorset, where I'm at the minute, they don't have. Somerset doesn't have any lawyers like that either. But yeah, so and if you've got a disability, again, maybe the easy way of doing this is to basically make a application for an assessment under the Care Act, so Section 9 of the Care Act, and you basically, which you trigger it via an email, and you'll get an assessment eventually if you complain. If you don't, basically, it's like they gatekeep as well, basically. But the social worker would potentially, if you've got what's called eligible, if you meet the eligibility criteria, which is kind of ticking a few boxes on a list, basically, then they would also be able to, first of all, advise you where there's some advocacy services, but they'd actually be able to advocate for you as well. So I would say that, if let's say you've got some difficulties understanding kind of, complicated writing, legal jargon stuff, then it might be that actually other organizations can specifically help you out and navigate that process.
Could I just add a bit? I'm sorry, it's my sort of number one theme in this is that no family should or no applicant should have to go through difficulties presenting their case because they don't have a case to present. The local authority has to make inquiries and process their application. All that the person really has to do is say, "Can you help me? I'm homeless," or "I need help with my homelessness." The, After that, the local authority should really say to them, "Okay, well, tell us about it and we'll ask you some questions and make inquiries." what they tend to do is send you an email with a whole load of questions and a list of things that you've got to do. And the suggestion, and actually more than a suggestion, is that if you don't provide that, then sorry, you can't have any help. But that is unlawful. And it's particularly, I mean, it's bad for anybody because it's difficult enough to fill all these forms in. But it just, I mean, if somebody's got a disability, it's ridiculous that they should be made to feel that they've got to get somebody else to help them when the council are under a duty to help them anyway. So please, if that happens to anybody, ask to speak, make a complaint to the manager and say you need help with your application from the
Yeah,
council, from the
yeah,
housing department.
yeah. You'll notice in the LGO decisions I put up as well, I think both of them resulted in a recommendation that the council receive Equality Act training within like 4 weeks or something. So that's another reason to complain, is it improves the service for other people. Right, I think that we'll try and make this the final question for the live chat, 'cause there's a few more that came in through the week that are not anonymized, which is why I'm kind of keeping them, holding them back. So I think it's a very straightforward one. Can a family with a household income of 40k apply for homelessness assistance? They can. They might not be able to get social housing at the end of it though, because there'll be 40k. I don't know actually. For a family, I think I'm trying to think like our local policy in Bedford. I think if you've got more than 30k, if you're a family, I can't remember the exact numbers, then you wouldn't be able to get social housing. But yeah, you can own your own home outright and make a homes application if you, for example, you were subject to domestic abuse. That in terms of how they've got absolute duties to provide accommodation, but the thing is, if you leave it to them, they're going to put you in an expensive hotel, and you will be, you won't be eligible for housing benefits, so you will have to pay for the temporary accommodation like out of your own pocket. So there might be better options if you've got that amount of money up your sleeve, but it is, it's a safety net which is there for everyone. You don't have to be completely broke to get the council to help you out, unless, I mean, again, I'm not kind of familiar with any case law about this, but as far as I know, they need to advise you about the implications on housing benefit, and if you have more than something like 16k, you can't get a housing benefit, but they would still have a duty to secure that accommodation is available for you, even though you're going to be the one who has to pay for it out of your own pocket. So yeah, Will, have I got that roughly right?
Yeah, I think you have. Yeah, I mean, there's no income limit to being able to make a homes application.
Cool. Okay, so we've got two more questions from the week, and unless there's some very quick questions that come up in the live chat, we'll call it a night, because I get the sense that both of us are flagging.
Yeah, I'm quite tired.
Yeah, got some long days tomorrow as well.
Mm.
So this person made a homes application on the 26th of June. They ask everyone for ID. I emailed them, and now they're saying you have a relief duty, which is 56 days. Do I have to do anything or just wait? I'm overcrowded on the council website. They say we do not apply for TA, but I am not sure what's going to happen to my application. I live in a one-bedroom flat. The homeless team came out to take some pictures and say because I've got somewhere to stay, they're not going to put us in TA. Whilst we all sleep in one room, and I explain the disrepair and mold and damp, I don't know why they haven't put me in temporary accommodation. So, and I think I'm pretty sure I got clarification from this question that there were children. I think there was like 3 children involved or something. So if this kind of relates to something I said a little while ago, if the council's accepted the relief duty, they're saying that they're satisfied you are in fact homeless, and therefore they have a duty to secure that accommodation is available that's suitable by definition. And this is not suitable accommodation. So I would, again, it would be exactly what I say all the time. Complain to the chief exec, copy in the relevant councillors, say, as far as I can tell, the council should have secured Section 188 accommodation for me, but they haven't. Bear in mind that the TA that the council then offer you might be, not much better than this, but they would be better than having 5 people living in one bed. I think. I don't know how bad London gets these days, but so the interim duty to accommodate has kicked in. But I think complaining is probably going to be the way it's always the way I deal with things basically, and just raise it with a chief exec, copy and relevant councillors, and wait to see what their answer is. And then the final question for the night, and there's some quick easy ones that came in just now on the chat. So someone's been served Section 21 no fault eviction, live in West Midlands, single mum, 2 children. I'm worried that I'll be left in temporary accommodation if nothing is available. 6 weeks left until the eviction date. Storage for furniture taken up most of the savings and I just worry about the relief duty happening to us. Does a officer council still help and stay in touch after the 56 days? I've heard of people being in a 6-month temporary accommodation or home privately short hold, but by then the council feel no duty of care to them. I saw a BBC YouTube video of a mum saying she'd been told to leave her hotel room at the time was up, and the council literally left her with no duty of care completed towards her. So
There's quite a lot in there.
yeah, a lot in there, but it's quite a simple answer. The simple answer is if you're in priority need, which this family are, then once the relief duty ends, the council doesn't just stop doing stuff. It then has to essentially make a decision about the main housing duty. If it's a Section 21 and you haven't, you're not intentionally homeless, then they're going to owe you the main housing duty. And that will involve continuing to provide suitable temporary accommodation for you during that period. So West Midlands makes me think this is Birmingham, which is terrible. However, that's what the law is. So again, as I keep saying, find out who your local councillors are now. So not only the ones that cover your current address, but also the ones which cover children's services, housing, and probably that's it for the time being. But those two, just there were two chairs of those committees. Copy them in as well. So you're going to have probably 4 councillors copied into the query, which is, I'm worried that I'm going to be left past the date, and so can someone explain to me what's going to happen? And that will kind of get the housing officer team actually doing something and giving you some advice, because actually nothing, it might be that nothing's actually wrong here yet. You're just worried about something that's going to happen in future, and they're not reassuring you. So all potentially all you want here is reassurance. On the facts I've just taken in anyway, I can't see any kind of massive issues. Bearing in mind as well that the council has a duty to protect your furniture and your belongings if you can't do it yourself. So check out chapter 20 of the Code of Guidance for more information about that. But yeah, I mean, the fact that the BBC YouTube video's got someone doing that, I mean, councils do it. They do it if they think they can get away with it. So what you're doing by involving those politicians is you're basically making it very difficult for them to get away with it, and you're giving them a kind of a motivation to not break the law. So I think we made it. Well done, Will.
Thank you.
Keep the questions coming on the comments on the videos on the channel. You back here next week, Will?
I hope so. Yeah, I was just wondering tonight. I thought, am I doing something next Thursday? But I don't think I am, so I should be okay.
Yeah, you're celebrating the end of certain politicians' political lives, hopefully, still in a
I'm
good
very
mood
much.
still.
I'm looking forward to tomorrow. Hopefully, I'm going to see at least a few of those devils losing their seats, which will be really nice.
Yeah, for sure. Cool,
So
man. Well,
I'm old
yeah,
enough. I can remember 1997. That's my problem, and that didn't turn out quite as well as. I mean, it wasn't as bad. Well, anyway, you got me
yeah.
started, but I'm looking forward to tomorrow. Anyway, it'd be good to see the Tories out.
Yeah, for sure. Yeah, cool, man. Okay, well, yeah, hopefully this has been helpful, guys. And yeah, again, hopefully this is going to make the difference in what you're going through. It's not, yeah, it's just tough. There's no way about it, and it shouldn't be happening, but it is. So yeah, but we'll see you next week. Take it easy.
Bye. Whoa.
Oh, bear with me. I was
Right.
still Zoom is